If you are a green card holder living in the United States right now, I need you to give me your complete attention for the next several minutes. Because a major new U.S. immigration law is set to take effect in 2026 that puts millions of lawful permanent residents at serious risk. This is not speculation. This is not social media rumor. This is verified, confirmed policy change that could affect your ability to maintain your green card, travel internationally, apply for citizenship, and remain in the country you have called home for years or even decades. My name is James. I have been a senior U.S. immigration professional for 6 years, and through Immigration News Today, I have dedicated my career to making sure you are never blindsided by changes like this. Stay with me until the very end of this video, because what I explain today could protect everything you have worked so hard to build in America. Let me begin by acknowledging what I know many of you are feeling right now. When you see a headline that says green card holders are at risk, your stomach drops. You feel a wave of anxiety wash over you. You start thinking about your family, your job, your home, everything you have invested in building a life here. And then the questions start racing through your mind. Does this affect me? What did I do wrong? Do I need to take action immediately? I understand these feelings completely because I speak with people just like you every single day. But I want you to hear me clearly. Today is not a day for panic. Today is a day for understanding and preparation. Because while this new law introduces significant changes, it is not the end of the world. If you understand what is happening and take the right steps, you can protect your status and continue building your future in the United States. As of date, a comprehensive new immigration enforcement and compliance framework has been finalized and is scheduled for phased implementation beginning in early 2026. This framework represents the most significant set of changes to lawful permanent resident requirements since the major immigration reform legislation of the 1990s. The changes have been widely covered by major news outlets including Reuters, the Associated Press, the New York Times, and the Wall Street Journal, and the official policy guidance has been released by the Department of Homeland Security through USCIS and CBP. What I am going to share with you today is drawn directly from that official guidance, verified against credible news reporting, and explained in plain language so that every green card holder, regardless of how long you have been here or where you came from, can understand exactly what is at stake. Let me walk you through the 5 major areas of change that put green card holders at risk under this new 2026 law. And then I will give you concrete steps you can take right now to protect yourself. The first major area of risk involves the tightening of continuous residence and physical presence requirements. Under the previous framework, green card holders had considerable flexibility when it came to international travel. You could generally travel abroad for up to 1 year without losing your status, and with a re-entry permit, you could stay abroad for up to 2 years. While extended absences could raise questions, officers had discretion in evaluating individual circumstances. That discretion is now being significantly constrained. The new 2026 rules establish a hard threshold of 180 consecutive days, approximately 6 months, as the trigger point for presumptive abandonment of permanent resident status. What this means in practical terms is that if you leave the United States for more than 180 days without obtaining prior approval in the form of a re-entry permit, CBP officers at the port of entry will have the authority to immediately begin questioning whether you have abandoned your permanent residence. If they determine that you have, they can initiate removal proceedings on the spot. But here's the part that catches many people off guard. Even if none of your individual trips exceed 180 days, you can still be flagged if your overall travel pattern shows you have spent more time outside the United States than inside over a rolling 36-month period. The new framework includes an automated tracking system that calculates your cumulative days present in the U.S. versus your cumulative days abroad. If your presence ratio falls below 50% over any 3-year window, you will be automatically flagged for enhanced scrutiny when you attempt to re-enter the country. The second major area of risk involves the expansion and codification of the public charge rule. The concept of public charge, meaning someone who is primarily dependent on government assistance, has been part of immigration law for over a century, but its application has varied dramatically depending on the administration in power. The new 2026 law removes that variability by codifying a clear, enforceable standard. Under the new rules, if you have received certain designated public benefits, including cash welfare, supplemental security income, long-term Medicaid coverage, SNAP benefits, or Section 8 housing assistance, for more than 12 months within any 36-month period, you can be considered a public charge for immigration purposes. This determination can affect your ability to apply for naturalization, and in some cases, it can be used as grounds for removal. Most critically, this provision applies retroactively, meaning benefits you received years ago can now be considered in current and future immigration decisions. The third major area of risk involves new mandatory biometric reporting requirements. Starting in 2026, all lawful permanent residents will be required to appear at a USCIS application support center every 5 years to provide updated fingerprints, photographs, and signatures. This is a completely new requirement that did not exist before. The purpose, according to official DHS statements, is to maintain accurate identity records and ensure ongoing compliance with immigration status requirements. What you need to know is that failure to comply with this biometric reporting requirement within 90 days of receiving your notice will result in your green card being declared invalid. An invalid green card means you can be denied boarding on international flights, stopped at the border, and potentially placed in removal proceedings. The fourth major area of risk involves expanded criminal history review and reduced judicial discretion. Under previous rules, immigration judges and USCIS officers had some flexibility in evaluating how criminal offenses affected immigration status. They could consider mitigating factors, the age of the offense, evidence of rehabilitation, and the overall circumstances of the case. The new 2026 framework significantly reduces that discretion. The law expands the categories of offenses that are considered automatic bars to naturalization and automatic grounds for deportability. It lowers the threshold for what constitutes an aggravated felony under immigration law. And it requires USCIS to automatically conduct a complete criminal background review for every green card holder who applies for naturalization. If any disqualifying offense is discovered, even one from decades ago that you thought was resolved, your citizenship application will be denied and removal proceedings may be initiated. The fifth major area of risk involves stricter address reporting and documentation requirements. Under previous rules, green card holders were technically required to report any change of address to USCIS within 10 days, but enforcement was essentially non-existent. The new 2026 framework changes that completely. Failure to report an address change within 10 days is now classified as a misdemeanor criminal offense, and repeated violations can be used as evidence in removal proceedings. Additionally, green card holders are now required to carry their valid green card at all times when in the United States. Failure to produce your green card upon request by an immigration officer can result in civil penalties starting at $250 per violation and increasing with each subsequent failure. Now that you understand the 5 major areas of risk, let me give you the concrete steps you need to take right now to protect yourself and your family. Step 1. Locate your green card immediately and verify that it is valid and not expired. If your green card is expired or will expire within the next 12 months, you need to file Form I-90 for renewal as soon as possible. Processing times are increasing, and under the new rules, having an expired green card creates significant complications. Do not wait until the last minute. Step 2. Log into your USCIS online account or create one if you do not already have one. Verify that the address on file is your current correct address. If you have moved at any point in the past and did not file Form AR-11 to report the address change, you need to do that immediately. This form can be completed online in just a few minutes, and doing so now could prevent serious problems later. Step 3. Review your travel history for the past 3 years. Calculate how many days you have spent outside the United States versus how many days you have been physically present. If your presence ratio is approaching or has fallen below 50%, you need to seriously consider limiting international travel and remaining in the U.S. for an extended period to rebuild your ratio. If you know you will need to travel abroad for an extended period in the future, apply for a re-entry permit using Form I-131 before you leave. Step 4. Gather and organize documentation proving your continuous residence in the United States. This includes federal and state tax returns, utility bills, lease or mortgage documents, employment records, bank statements, health insurance records, and any other documents that demonstrate you have been living in and maintaining ties to the United States. Put all of this in a secure folder that you can access quickly if you ever need to present evidence of your residence. Step 5. If you have ever received any public benefits, Medicaid, SNAP, housing assistance, or any other government programs, document exactly what you received, when you received it, and for how long. Consult with an immigration attorney to understand how your benefit history might affect your status under the new public charge rules. If there are ways to mitigate potential problems, an attorney can help you identify them. Step 6. If you have any criminal history whatsoever, and I mean any history at all, even minor offenses from many years ago, even things you thought were dismissed or expunged, do not apply for citizenship, do not travel internationally, and do not take any immigration action until you have consulted with a qualified immigration attorney. The new expanded criminal review requirements mean that things you thought were behind you can suddenly become serious immigration problems. Get professional guidance before you do anything. Let me share a real-world example that shows exactly why preparation matters. I recently worked with a green card holder named Carmen, who has lived in the United States for 16 years. She is a devoted grandmother who travels frequently to visit her grandchildren in Colombia. Over the past 3 years, Carmen made 5 trips totaling approximately 200 days abroad. Under the old rules, this would not have been a problem. Each individual trip was well under 1 year, but Carmen's presence ratio was only 68%. When she returned from her most recent trip, the CBP officer flagged her file for review. She was questioned for over an hour about her ties to the United States, her reasons for traveling, and her intent to maintain permanent residence. Carmen was ultimately allowed to enter, but she was shaken by the experience. She told me she had no idea her travel pattern could create problems. Under the new 2026 rules, Carmen's situation would have triggered even more intense scrutiny, and she might not have been as fortunate. That is why I am telling you today. Understand the rules, prepare yourself, and take action now while you have time. I also want to address a question that I know is on many of your minds. Should you accelerate your plans to apply for citizenship? This is a complex question that depends entirely on your individual circumstances. If you are already eligible for naturalization, meaning you have been a green card holder for 5 years or 3 years if you are married to a U.S. citizen, and you meet all the other requirements, then yes, pursuing citizenship is generally the strongest protection you can have. U.S. citizens cannot be deported except in extraordinarily rare cases involving fraud in the naturalization process. However, if you have any issues in your background, extended absences, public benefit use, criminal history, tax problems, then applying for citizenship can actually trigger a review of your entire file that might not otherwise have happened. Before you file Form N-400, consult with an immigration attorney who can assess your specific situation and advise you on whether it is safe to proceed. I know this is a tremendous amount of information and I know some of it is frightening, but I want to leave you with a message of hope and empowerment. Yes, the new 2026 immigration law is stricter than what came before. Yes, there are real risks that green card holders need to take seriously, but these rules are not impossible to follow. Millions of lawful permanent residents will continue to live, work, and thrive in the United States by simply understanding their obligations and meeting them. The difference between those who have problems and those who do not is preparation. And by watching this video, by learning about these changes before they catch you off guard, you have already taken the most important step toward protecting yourself. As we come to the end of this video, I want to remind you why Immigration News Today exists. This channel is here to give you the truth, the full, verified truth, as soon as it happens, so that you can make informed decisions and protect your future. I will never hide difficult news from you, but I will also never leave you without direction or hope. There are always steps you can take, and there are always people who can help. If this video helped you understand the new 2026 immigration law and what it means for green card holders, please take a moment to like it, share it with every green card holder you know, and subscribe to Immigration News Today with notifications turned on. I am monitoring these policy changes every single day, and the moment there is any new development, any guidance, any clarification, any court challenge, you will hear about it here first. Before I go, I must give you my standard disclaimer. Everything I have shared today is for general informational purposes only. It is not legal advice. Immigration law is complex, and your individual situation may have factors that require professional evaluation. Please consult with a qualified immigration attorney or accredited representative for guidance specific to your case. Always verify information with official government sources, including USCIS.gov and DHS.gov. Policy can change, and the information I have provided is accurate as of date. Thank you for trusting me with your time and your future. You are not alone in this. Together, we can navigate whatever changes come our way. My name is James, and this is Immigration News Today. Stay informed, stay prepared, and I will see you in the next video. Take care of yourself and take care of each other.